Hi, I am Denise Newton Fitzpatrick. I am an advocate for the mentally ill and also the homeless in regards to housing discrimination. I'm a fighter for civil rights, an advocate for equality. Several years ago, I was recognized by an executive director of the ACLU as an activist and a key most dedicated people power action leader. I am going to show you how I defeated a government entity with their laws, and you can too. In the first part of this video, I am going to talk about the actual what happened. Then I will tell you later on in the second part the laws that were violated and the statute, the codes, on the federal 42 U.S.C, which is health and welfare. In the year 2014, my son was excluded from housing because he has mental disabilities and schizophrenia. Housing discrimination against my son is also discrimination against me as one who is associated with him. The local government entity that made housing unavailable for my son is authorized by the federal government to provide housing for those who have mental disability, saying that those with mental disability are members of a protected class. My son was eligible for the housing because of mental disability, but then he was excluded from housing because he has mental disability. After my son was excluded from housing, I attended a housing orientation. I signed to the program guidelines that a participant can request a change in family composition. Therefore, I did a reasonable accommodation request. A reasonable accommodation request is a change in rules, policies, and procedures to allow a person enjoyment in housing. Because my son was excluded from living with me in housing, that deprived me of enjoyment in housing with or without him. That's a violation of the Fair Housing Act. The Fair Housing Act was signed by Lyndon Baines Johnson in the 60s. But in the year 1988, it was amended to include the members, as mentioned, of a protected class. When I did the reasonable accommodation request, I sent that request to the housing management of the one-bedroom unit that I had. I also sent it to an assistant housing director of the local government entity. The apartment manager approved the request, waiting for such approval from the local government entity assistant housing director. But after 10 days, we heard nothing from the local government entity assistant housing director. To ignore a reasonable accommodation request is the same as denying a reasonable accommodation request. To deny a reasonable accommodation request is a violation of the Fair Housing Amendment Act of 1988. After the denial, because it was ignored, I began to be harassed and intimidated by the local government entity assistant housing director, stating that if I did not come in and sign to a new program, I would lose my subsidy, which was based on the income the rent was at the time. And I would lose my utilities because I received back then a utility allowance. The harassment and intimidation went on for about 5 months. Notes were left on the door. Emails were sent, threatening me that if I did not come down and sign into a new program, I would lose those things just mentioned. The new program would have changed the right that I had to request a change in family composition. In other words, if I would have signed into a new program, I would have been helping them to continue to keep the son out. Therefore, I continued to refuse. I even sent a cease and desist email to the assistant housing director of the local government entity. I said that if the harassment continues, then I will have to proceed accordingly. Cease and desist meant stop the harassment, or I'll proceed accordingly. It continued. Finally, after the months of harassment, I went in to the assistant housing director, not to sign any papers, but to ask if I could see the rules to the programs they wanted me to agree to. I already knew what they were trying to do because I knew the Fair Housing Amendment Act of 1988 as well as 42 U.S.C. codes. So then when I went on in, the assistant housing director, she came and met me, assuming that I was there to sign these papers to the new program. And when I asked to see the rules, the assistant housing director of the local government entity program told me I could not see the rules unless I signed into the program first. That made no sense whatsoever, and I refused again. In June of 2015, at the age I was then was 62, even though everybody, oh, you don't look 60, I was 62. Because I would not sign into the new program that would change the rules to the program I'd already signed into, my utilities were cut off in 90 and above degree weather. I was left with no air, no hot water, and no electric in 90 and above degree weather. I also received an eviction notice because the subsidy was stopped and I was unable to pay the rent. I wasn't retired then as I am now, and I was unemployed. Well, the eviction note came in, but I didn't go anywhere. I stayed there because I knew that my rights had been violated under the Federal Fair Housing Amendment Act of 1988. In November of 2014, I will step back for a minute, I filed a complaint against the government entity for making the housing unavailable for my son because he has a mental disability, and for denying the Reasonable Accommodation Request. All of those things are in violation again of the Federal Fair Housing Amendment Act of 1988. I battled with the government entity for 6 months because in June, when the utilities were cut off, I contacted one of the agencies that I had filed the complaint with and told them that I was without utilities. The lawsuit was filed and began as I alleged illegal housing discrimination under the Federal Fair Housing Amendment Act of 1988, 42 U.S.C. Code, Health and Welfare. And also, I stated it was in violation of the North Carolina Fair Housing Act. It was also a violation of the United States Constitution because it involved a government entity. It was a civil liberties violation, the American Disability Act. And later on, it became a civil rights violation because I proved the housing discrimination against the government entity in a court of law. So we battled with the government entity for almost 6 months. Well, after the beginning of the 5th month, the government entity filed a motion to dismiss. When the motion to dismiss was filed, I then had to have filed what is called a motion for preliminary injunction pending trial. If discrimination was found in the early phases of the lawsuit, the government entity would lose their motion to dismiss, and I would be granted my motion for preliminary injunction pending trial. On September the 29th, 2015, the case went before the district court. Well, there was a cross-examination on September the 29th, 2015. Wake County, the government entity, lost their motion to dismiss because illegal discrimination was found in the early phases of the lawsuit. You can defeat a government entity in illegal housing discrimination if you know the 42 U.S.C. codes, health and welfare. In order to determine that discrimination had indeed occurred, the judge took several factors into consideration. He took notice of the files. He took notice of all the evidence that I showed to prove the harassment, the emails, the notes left on the door. And also I had proof that when I went down, after being threatened if I didn't come down to see the rules, I would lose my subsidy and utilities. I had proof that I went down and was not allowed to see the rules for the new program when I asked. What proof did I use for that? Well, the attorney who took the case up after I contacted them, again, saying that utilities were cut off and I had filed a complaint months before that, she spoke with the government assistant housing director. The assistant housing director said that I never came down to the program to see the new rules. There was no need for me to do that anyway because I'd already signed into the rules of the program that we belonged in. But the assistant housing director said I never came down to see the rules. Well, then when the lawyer said, may I see her file, she had wrote in the file that I did come down, and when I asked to see the rules, she said she refused to let me do that. I was found by the judge to have clearly established a prima facie case. That's P-R-I-M-A, F as in Frank, A-C-I-E. What that is at first appearance, the judge could look at the case because of my evidence in the statutes, the federal statutes that were entered into the lawsuit. He can look at that and see that the case was illegal discrimination. The cross-examination only put the icing on the cake. Because the cross-examination proved that my son was indeed excluded from housing because he had a mental disability. It proved that I had told the truth all along. Because since I would not sign into the new program without seeing what I was signing, utilities and all was cut off in the eviction note. The judge looked at all of that, and I was found to have clearly established a prima facie case. This is the first part of this. I am going to go to the second part, which will be another video. And in that video, I will show you the 42 U.S.C. codes, what they mean, and how you can win a lawsuit against a government entity by simply knowing the statutes. I will be back to explain further how you can win against a government entity in a case of illegal discrimination using the federal statutes and their laws. Have a good evening. Goodbye now.